Hello friends, in the series on the income tax cases, today we will discuss the case of National Faceless Assessment Center and others versus Chander, Arjandas, MANWANI. This case has been reported in 453 ITR at page number 236. The matter has been decided by Supreme Court and the date of the judgment is 21st March 2023. This case is regarding section 144B subsection 9 that talks about broadly for faceless assessment. There are number of the procedures which are given in section 144B. One of the important provision was section 144B subsection 9, which was saying that if the assessing officer does not issue the draft assessment order before finalizing the assessment which is against the assessee, then that order will be non-est. After that, a circular of the department came dated 13th August 2020, which was peri materia with this provision, which was also saying that any order passed without issuing the draft assessment order was non-est. The assessee filed a writ petition into the High Court and the High Court quashed the assessment order because assessment order was not passed without passing the draft assessment order. Meaning thereby that in this case the assessment order was passed and draft assessment order was not issued to the assessee and opportunity was not given to the assessee. Because of the direct provision, the High Court gave the relief to the assessee. But as all we know that this provision was deleted with retrospective effect by the legislature, because a number of the judgments came from the High Court about quashing the assessment orders which were passed without issuing the draft assessment order. This is also a very painful thing for the assessee, that whatever the provisions are there for making the tax administration system better, that are deleted with retrospective effect, and simultaneously the circular was withdrawn dated 13th August 2020, which was peri materia with the section 144B subsection 9. When these provisions were amended, the department went to the Supreme Court and said that these provisions have been deleted with retrospective effect, so the order of the High Court should be quashed. Supreme Court said that both the circular dated 13th August 2020 and section 144B subsection 9 has been deleted with retrospective effect, so the assessment order which was quashed by the High Court is not valid, and the Supreme Court remanded the matter back to the assessing officer for rehearing. Friends, this is a very painful thing for the assessee, that if some procedures are there which are to be followed by the department, then the assessee has no rescue for him. Even if he will go to the court that these procedures are not being followed, then there is no penalty, there is no cost on the department. Simply the court says that you have to again go to the assessing officer and plead before him. A number of the cases, a number of the special leave petitions have been decided by the Supreme Court in favor of the department. With due respect to the Supreme Court, with these judgments, the department will pass the orders in a very random manner and by not following the decisions. In one more case which was on the same pattern, the Supreme Court said that because these provisions are new to the department, so in these cases the department should be given an opportunity again for rehearing the matter. And in one case on the same pattern, the Bombay High Court made very good remark on the department that if such orders are passed without following the procedures, then in those cases the heavy cost should be imposed on the officers and that cost should be recovered from their salary, and those judicial orders should be marked in their career. It is very surprising and interesting that the department also filed the special leave petition for questioning this derogatory remarks, and the Supreme Court also gave the decision in favor of the department and deleted these remarks. Friends, if these type of judgments will come with due respect to the Supreme Court, then it is very painful for the assessee that if the procedures are not being followed by the assessing officers, then there will be no rescue for the assessee, just a round litigation, and a number of the rounds of litigations you can say. At the end of this video, once again I am repeating the name of the case. The name of the case is National Faceless Assessment Center and others versus Chander, Arjandas, MANWANI. And this case has been reported in 453 ITR at page number 236. The matter has been decided by Supreme Court and the date of the judgment is 21st March 2023. Thank you, friends.